Kuwait Airways Corporation versus Philippine Airlines Incorporated, GR number 156087, May 8, 2009.
PAL entered into a commercial agreement with Kuwait Airways. Under the said agreement, Kuwait Airways obligated itself to share with PAL revenue earned from the uplift of passengers between Kuwait and Manila and vice versa. In 1995, delegations from the Philippine panel and Kuwait panel met in Kuwait. The talks culminated in a confidential memorandum of understanding. Among the members of the Philippine panel were officials of the Civil Aeronautics Board, the Department of Foreign Affairs, and 4 officials of the Philippine Airlines. A provision in the CMU provides that the exercise of the 3rd and 4th freedom traffic rights shall not be subject to any royalty payment of commercial agreements, and that the agreement may be terminated by either party with 90-day notice and at the last day of the traffic period. Petitioners sent a letter notifying PAL that by virtue of the CMU, the termination of the royalty payment is in effect. PAL insisted that the agreement could only be effectively terminated on 31 October 1995, or the last day of the then current traffic period. The Philippine Airlines insisted that the provisions of the commercial agreement shall continue to be enforced until such date. PAL demanded that Kuwait should pay the revenue for the remaining period of the agreement. Petitioner refused to pay the principal sum. Thus, PAL filed a complaint before the RTC, which ruled in its favor. RTC, in resolving whether PAL is entitled to the sums claimed under the terms of the commercial agreement, favored PAL in its decisions, and ruled that the CMU could not prejudice its existing rights under the commercial agreement. The issue is whether or not the Civil Aeronautics Board, or CAB, having authority over the air transport, can compel PAL to terminate the commercial agreement with petitioner. The Supreme Court said no. There is nothing to prevent the Philippine government from utilizing all the proper channels under the law to enforce such closure, but unless and until due process is observed, it does not have legal effect in this jurisdiction. Even granting that the agreement between the two governments or their representatives creates a binding obligation under the international law, it remains incumbent for each contracting party to adhere to its own internal law in the process of complying with its obligations.